Regarding in the break, somebody asked me about the judges, how they're appointed. They're suggested by the member states, and they're appointed accordingly, but it doesn't mean that automatically, which means that all other member states should also approve that suggestion. But usually you would be suggesting a person that's going to be approved. So it's more or less an automatic process, but there is a kind of a monitoring mechanism regarding their appointment as well. So that's one thing, I think, one clarification to make.
Which institution approves their nomination?
There's no institution approving, it's the member states. They will have a kind of a consensus about the names that have been proposed. Sorry? For the ECJ, for the judges, for the...
But like approval takes place in the ECJ then?
It's taking place by the governments. There's no like a physical ECJ, I mean, there's no physical place. So there is a need of a judge being changed, and they also have a limitation regarding the time limit to serve. For example, I had a friend whose father was the judge, the Portuguese judge in the European Court of Justice. And after his period has ended, he was a judge before in Portugal. He was working as a judge in Portugal, and then he has been proposed to become the Portuguese judge in the European Court of Justice. As you can imagine, it's a very prestigious position, and it's a very honorable position to serve. So it's quite also critical and important because they handle lots of important cases, and the European Court of Justice has the power to actually fine, unlike most other international courts. They have the power to actually impose a fine. So they actually punish the member state or the institution or the individual as well. So they actually have a power compared to other most of other international courts. It doesn't only work on diplomacy. That's what I'm trying to say. And their decisions are binding. The European Court of Justice's decisions are binding. So the cases when they're solved, the decisions are binding. The member state has to oblige by the decision that's been taken by the European Court of Justice. What we're trying to see here with the nature of the community law, with the supremacy and direct effect, is one issue regarding the international law, basically. I have an advantage of teaching you because you have taken already international law classes, public and private international law, so you have the basic concept of international law and the issue of sovereignty, basically, egemenlik meselesi. In the international law, the sovereignty issue is quite critical, and when the in 1957, when the Rome Treaty and the European Economic Community was established, they assumed that it's going to be a regular international institution, as any other institution. And in the regular international law setting, what is important is that the member state is important, or the signatory state is basically important. The signatory state will define the boundaries of that organization or the treaty. So when they're delegated in that sense, they are able to control the organization or the treaty. So it's not the other way around. So with the decision of the Wangen laws, what the European Court of Justice judges were trying to say or give the message is that, unlike what you were thinking in the beginning, this is not an international law setting. We're talking about a new legal order. So we are limiting the sovereignty of the member states here. So what you're trying to do is, then the issue of competences came into being. What we're trying to do is that it's not the member state trying to limit, it's the other way around. We can actually limit the sovereignty of the member state. That makes it different for the EU law and the European Union right now than any other international organization. Similar things were trying to be established in terms of the regional integration processes in different parts of the world. But what makes the difference is that they don't necessarily have that kind of a legal system. But in 1957 and later, that's why the role of the European Court of Justice is very critical. But what happened is that this role and this judicial activism of the court was also being accepted by the member states. So the member states actually accepted that decision, and they were okay with limiting their sovereign power. That makes the difference. That's why it's very critical, and that's why it's very different and important. So we're discussing about the sovereignty issue here. Not only a legal concept or the doctrine, this and that. We're discussing about the competences and yetki alanları, yetkinlik, and who's doing what, the member state versus the European Union, and at that time European Economic Community obviously, and how much power they have over each other. And that how much power over each other in terms of the EU level versus the member state level has constantly been an issue of discussion, negotiation, this and that. As we can see from the European Court of Justice though, sometimes it's beyond the control of the member states. After they create an institution, sometimes these institutions can actually take the initiative and do things. And this is usually the cases in certain institutions that once they're created, it's very difficult sometimes to control them. I mean, no matter how you can try to implement mechanisms to be able to, in that sense, monitor their power or their functions. So that's a very interesting and important example. So nowhere in the EC Treaty is that it's possible to find an explicit commitment to the idea that the community law shall be supreme, nor the notion that it shall be directly effective. So it's not written explicitly. There's nowhere in the Rome Treaty you say, this treaty creates a supreme law system, or it's going to be directly effective. It was the interpretation of the European Court of Justice. Also, the court has deducted these existences, both these fundamental principles from the object of the treaty. So that's why it's important, and that's why it's very unique that the EU law system was able to get developed from these basic concepts, and it then further supported the integration process. So if you have to look in detail, we discuss with the Wangen Loss case, this is the substance from Germany to Netherlands, and it was brought in front of the Dutch courts, and it was asked whether or not the Rome Treaty Article 12 can be applied there, that this violated the principle of free movement of goods. As you imagine, it was with the Rome Treaty, we're trying to create a single market, which took about 30 years with the Single European Act. But the movement of goods from one member state to the other member state, there should not be any customs tax. So that's why Wangen law said that it paid such a duty, and that duty should be reimbursed. And the Dutch courts, with the preliminary reference that we discussed earlier, asked the European Court of Justice whether or not this article could be applied in front of a private litigant in front of a national court. So the first question the European Court of Justice had to, in that sense, look into is that whether Article 12 has direct application in the national law or not. In the sense that the nationals of member states may, on the basis of this article, lay claim to rights which the national courts must obviously protect. So not only the member states, so whether or not a company or an individual in this, I mean individual in the sense of a company basically, not only the member states, but whether or not the individuals should be under this obligation. So what happened is that it's said that the objective of the European Economic Community Treaty, which is to establish a common market, the functioning of which has direct concern to the interested parties in the community, implies that the treaty is more than an agreement between mutual obligations between the contracting parties, but it has extended its power in the respect that because of the preamble of the treaty, and I will show you the preamble of the treaty, what the preamble of the Rome Treaty actually says, because it has references to the people. That's why it not only binds the member states or the governments, but also to peoples as well. Here's the Rome Treaty. In the Rome Treaty preamble, ön sözünde yani, Antlaşmanın ön sözünde, determined to lay the foundations of an ever closer union. You heard probably a lot of times this ever closer union phrase among the peoples of Europe. So it doesn't say states, it says peoples of Europe. So because of that, the judges interpreted this preamble saying that it doesn't only create a contract between member states by signing this treaty, but at the same time, it also gives rights to the people, because the treaty is directly referring to the peoples, to the citizens, to the individuals. Resolved by thus pooling their resources to preserve and strengthen peace and liberty, and calling upon other peoples of Europe who share their ideal to join in their efforts, have decided to create a European economic community. So the people create, the people of Europe, in that sense, or the peoples of Europe created the European economic community, not member states only, so the people. So that gives them the right. So this treaty gives those citizens the rights in that respect that are coming through the provisions of this treaty. So the judges use the preamble, so they become a bit creative in that sense in terms of interpreting the treaty. So they didn't take the more conventional route, but they put a bit more, in that sense, creative understanding to the treaty, and they come up with this interpretation. That's why law is quite important, because you have to interpret how this treaty has to be interpreted. And the decision was as follows, we discussed. It's the community, this was the decision of the European Court of Justice. So the European Court of Justice come up with the conclusion that the community constitutes a new legal order of international law. So they're saying basically forget about the international law you used to know. This is a new legal order of international law, for the benefits of which the states have limited their sovereign rights. So with their signature of the Rome Treaty, these member states accepted to limit their sovereignty. And with their limited, obviously the limited field, so you have to keep in mind that they didn't limit their sovereignty in every field, just under the provisions of the Rome Treaty, whatever is being listed in the Rome Treaty, they were limiting their competences. And the subject of which compromises not only member states, but also their nationals. So to the nationals, the citizens as well. Independently of the legislation of the member states, community law therefore not only imposes obligations on individuals, but it also conferred upon them rights. So not only obligations, but rights as well. What does that sound for you when they say that? And they also say that it's become part of their legal heritage. So it becomes their national law as well. And these rights arise not only where they have expressly granted by the treaty, but also the reason of the obligations which the treaty imposes in a clearly defined way upon individuals, as well as upon member states and upon institutions of the community. So it kind of interprets in a more extended manner. So they're not really limiting themselves here when they're in terms of their interpretation. So when you read this, you see that it has power on individuals. It has power on member states, and it also has power on the EU institutions. There is one other thing. If you go back to the sentence, the community law therefore not only imposes obligations on individuals, but it also intended to confer upon them rights, which became part of their legal heritage. What does it sound like if you read that sentence? Because we will be referring to this a bit later as well in the following week, basically. Not only obligations and rights. In what kind of a text we have not only obligations but rights? In the national settings. As a Turkish citizen, what kind of obligations and rights you have? Which document sets those rights and obligations? Constitution, right? I mean, it's the Constitution in every state. The Constitution will explain your rights and obligations. So it's why I'm critical here. Although initially they didn't really have an intention to say that it's going to be, giving certain rights to the signatory state citizens, here we start to see the constitutionalism within the European legal system. That's called constitutionalism. So not necessarily they're saying that Rome Treaty is a constitution. It doesn't say anywhere in the Rome Treaty that it's conferring rights upon individuals, but the interpretation of the European Court of Justice, how they interpret the Rome Treaty is in a way that it interpreted, and the decisions that it took, that we will be seeing next week as well, that brought constitutionalism into the EU legal system without a constitution, basically. So that's why linking those arguments now from 1960s, we're discussing about 1960s, to 2009, to the Lisbon Treaty. Lisbon Treaty in that respect was an inevitable consequence of what has been developed over the years from Rome Treaty onwards. They referred it as a constitutional treaty or not, doesn't matter, but it at least legalized what has been going on through the European Court of Justice decisions, that this constitutionalism without a constitution continued to happen from 1960s onwards, and the Lisbon Treaty was an answer to that. So that's why we have, and next week I will be bringing you the Charter of Fundamental Rights as well. That's why they had to have a list of those rights in one of the treaties, basically, because this was already being decided by with the European Court of Justice court decisions. Article 177 and Article 284. It's the secure uniform preliminary reference, basically, to secure uniform interpretation of the treaty by national courts and tribunals, and it confirms that the states have acknowledged that community law has an authority which can be invoked by their nationals before those courts and tribunals, basically. So you can, national courts have the power in that sense to have the authority to have the community law to be invoked for their nationals. So the sovereignty of the European law was not stopped there. So it's just one decision by the Wangen and Loss case. It was further developed by the Costa versus Enel case. It was shortly decided afterwards in 1963, sorry, 64. Costa is an individual and concerned an Italian law that sought to nationalize the electricity production and distribution industries. Costa, a shareholder of the Edison Volta company, a company affected by the nationalization, ulusallaştırılmış bir şirketten bahsediyoruz. Daha önceden özel bir şirketmiş, daha sonradan ulusal bir şirket haline getirilmiş. Claimed that it breached the community law. And the Italian government claimed that the matter was one of the Italian law, as the Italian legislation postdated the EC treaty, and for that reason should be held to be applicable. That should be the applicable law. So what happened that a company has been nationalized, and the person who was a shareholder in that company said that it's breaching the European Community law. That's why the European Community law has to be applied instead of the Italian law. And the Italian law is saying that, oh, well, this is postdated the Rome Treaty, and that's why it should be the Italian law that has to be applied, and has nothing to do with basically the European Community law. So as this conflict arises and how to interpret the Rome Treaty or not, the case has been brought in front of the European Court of Justice. And the European Court of Justice took this initiative of deciding on this case and interpreted in a way that we will come up with a different doctrine now, the supremacy doctrine, basically. And it says that with an ordinary international treaty, by contrast to an ordinary international treaty, that the European Economic Community Treaty was created its own legal system, which on the entry into force of the treaty became an integral part of the legal systems of the member states, and which their courts are bound to apply. So if you're a signatory to the Rome Treaty, and if you become a member state of the European Economic Community, which means that you have to apply these treaties, and there is no exception. And because it's been created, the community has been created by unlimited duration, having its own institutions, when it started with the institutions, its own personality, its own legal capacity and capacity of representation on international plane, and more particularly the real power stemming from a limitation of sovereignty or transfer of powers from the states to the community, The member states have limited their sovereignty rights. So it's again the issue of sovereignty here that we have to do. So it's declaring that by accepting being part of the European economic community, you're accepting that you're limiting your sovereign rights. And this is an indication. But also in the limited fields again, whatever is being defined in the Rome Treaty, not in every single field. And have thus created a body of law which binds their national and themselves. And in case of conflict, basically, this is what they're trying to say here. What they're trying to say here, if you decide to become part of the European Economic Community and sign the Rome Treaty, it's no longer the ordinary international law. You are limiting your sovereignty. And whether you like it or not, whether you're noticing it or not, with this, it's no longer like the cases of the international law. In those cases, the member states have the power to be able to control, and they don't necessarily limit their sovereignty in the international organization that has been created, and they can actually rule that international organization. It's the other way around here. We are talking about a different system than the traditional international law, and here you're creating a community body of law that will bind yourself as a member state, but at the same time you're binding your nationals as well. And with this interpretation, it has been accepted that, with the Costa and Anil case, has been accepted that the European Union law, at that time the European Communities law, has supremacy over the national law. So if there is a case of a conflict, if there is a national legislation that is in conflict with the provisions of the Rome Treaty, or with the EU legislation basically, it should be the EU legislation that has to be taken into consideration. So it's quite a significant shift from this classical understanding of international law. There is a conflict, it is the EU law has supremacy over the national law. It is directly applicable, and at the same time, it has supremacy over national legislation. Why it has to have supremacy over national legislation? Any ideas? No ideas? Let's think about 1960s. We have 6 member states. In those 6 member states, there are 6 different national legislations, and there's provisions about everything that you can think of. And these different types of law, and there are different types of provisions, let's say there is no supremacy. Let's think about it as a traditional understanding of international law. What will happen is that if there is a provision that will be, let's say, in conflict with the Rome Treaty, and let's say the French court will decide that the national law will apply, and in that particular area, the European Communities law is not going to apply, and they're going to apply accordingly. In another provision, let's say the Dutch national court will say that for that particular provision, a different interpretation will happen, and there is a conflict, and they cannot apply that particular provision on that because there is a Dutch legislation regarding that particular issue. It's not, there will be different applications of the Rome Treaty in terms of conflict. So we can see that different applications of the Rome Treaty in 6 different member states. So we cannot talk about a functioning of a common market. 6 member states, 6 different legal systems, different courts, and each one will be deciding according to their legislation or their constitution, this and that. You will be creating chaos, basically. Because of that, in order to create this uniformity of application, they had to say that there is supremacy. And with regards to the EU legislation, with regards to the European Communities legislation, we cannot question the conflict between, we cannot question the conflict between the national legislation, between the EU legislation. If that's the case, the EU legislation takes precedence and full stop. This would end this confusion, basically. That was the whole idea. Because you have to make sure that the same treaty and the same legislation or the same directives, regulations are applied accordingly in each and every member state. That constitutionality of the Rome Treaty with regards to national constitutions or uniformity between these legislations cannot be questioned. Because it will make things more complicated and it will make the whole system not workable, basically. So that's why they have to come up with the supremacy principle or doctrine. Is that clear? The EU law sovereign has three main implications in that respect, and these three implications is about primacy, competence, and fidelity. The primacy of EU law means that the law governs the conditions of its application unless it expressly provides. It cannot be disapplied in favor of any other form of law. The second one regards the competence issue. So the EU law determines the limits of its own authority. It is for the EU law to determine the extent of the EU law-making powers or the competences and what affects the existence and exercise of these competences that can actually bring. And the third one is regarding the fidelity. The sovereignty of EU law establishes a rule of law which all public institutions within the member states are subject, including national courts. So the national courts, including national courts, has to be applied and accepted. So the fidelity issue, the competence issue, and the primacy of the EU law issue. So those are the three different kind of implications that was brought forward with those interpretation of those cases. And you have to remember those two cases and what kind of results that they achieved, or what kind of doctrines they brought, and what kind of implications it had into the European integration process in general. You don't have to remember the details about the cases, what happened, this and that. Those are not important. Those are not critical for us. It's been just stated so that you can understand the case. But what is important is the result, the implication of that case. That is the important thing. How the court took the initiative to take its role a step forward, basically, to be able to first of all establish a legal system, so that kind of role it gave it to itself, and second of all to make sure that those certain principles are being developed so that the member states should be able to follow a certain route in terms of understanding and applying and implementing the EU law. Any questions? Any comments?